All right, I think we should go ahead and get started. I don't want to keep you waiting. Good afternoon again, everyone. Happy New Year. I hope you're all enjoying your January, which for me has absolutely flown by. We're already at January 25th somehow. I'm excited to announce that we are now offering MCLE credit during these monthly webinars. MCLE is Minimum Continuing Legal Education for California attorneys. We are, of course, still offering CE credits for California workers' compensation adjusters. Don't worry, we would never forget about you. Important announcement, though, for attorneys and claims examiners, you must be on the webinar, able to see the slide presentation, and attend for the entire hour to receive credit. I'm going to say that one more time, okay? For attorneys and claims examiners, so everybody who's on here, you must be on the webinar portion and be able to see the slides and attend for the entire hour to receive credit. If you have any questions about that, you can always shoot me an email or give me a call. If you haven't already, I recommend that you visit our website at bradfordbarthel.com for tons of information about Bradford and Barthel, and also a plethora of value-added services. A few of those include our training page, which now has 80+ hours of continuing education credit available to claims examiners. Yes, I said 80 hours. I counted recently and we're up to 80 hours now. So do take advantage of that if you need additional CE credits. Additionally, you can register for upcoming webinars. Our February and March webinars are available for registration now. Our B&B blog is pretty amazing. Our attorneys write an average of 2 new articles a week on current workers' compensation topics. And finally, have you heard about our AMA analysis and rating department? That department fully analyzes and annotates medical report shortcomings, outlining sections that either need to be bolstered or undercut, depending on the client's objectives. Do go check out your GoToWebinar panel and find the handout section. You're going to find a copy of today's PowerPoint presentation in the handout section. If you have any questions during today's presentation, please enter them in the questions section and we will do our best to get them answered during the presentation. John Kamen and William Bartels, we call him Bill, they're presenting today's presentation on best practices for lien litigation and resolution. We also have David Lim here from our Santa Rosa office to greet you. David, would you like to start off our intros?
Yes. Hi, everybody. Good afternoon. My name is Dave Lim. I'm the managing attorney out of our Santa Rosa office. I've been here for over 10 years now. Time flies. But our office does service Santa Rosa, Oakland, San Francisco, and Ukiah. So if you do have any questions, my door is always open to you. I believe that our emails were just recently posted on this PowerPoint presentation. So feel free to reach out anytime.
Okay, and good afternoon, everybody. My name is John Kamen, and I am an equity partner in the Woodland Hills office, and I'm also director of the editorial board. And that's a fancy way of saying that I run the firm's blog. So if you have any blog ideas, please feel free to send them over to us, because actually you're our greatest source of good blog ideas. We get our best ideas from you, the clients. And so if you do have anything unique or that's puzzling, feel free to send it over to us and we'll be happy to take a look. As far as when it comes to liens, I've had many wild lien trials. And actually right now, speaking of blog ideas, we do have a lien series of blogs. So we're doing about 1 blog a month on basic lien topics. And so it does cover some of the stuff that we'll be covering today. So if you do find yourself a month or 2 from now with some lien questions, check out the blog. It may have the answer on there. About my background, I do have a prior career as a journalist, and I was the legal editor at WorkComp Central for about 6 years. And there I also covered a bunch of lien stuff as well. And so with that, let me kick it over to Bill Bartels to get our presentation started.
Hello, everybody. Thank you, John. Thank you, David. And thank you, Tammy. My name is William Bartels, and I'm just a Bill. And I don't have much more to say about that. No, I've been with the firm for about 10 years now, over 10 years, actually. And David's right, time certainly flies. I also had a previous career doing criminal law, family law, and some civil law, some copyright infringement. So I've dabbled quite a bit in my 20-year career. I've been lucky that way, and I'm happy to be here with our B&B folks. Happy to talk to my brothers and sisters in the attorney field and the claims adjusters out there with whom we happily work. So I know the topic today, we'll just jump right into it. It's not one of everybody's favorites because it's not one of my favorites, but I understand it's important, and especially for those of us in the Southland, it's a critical part of any claim. So it's good to know, it's good to have some understanding about these things. I think we tend to overlook liens just because they stink and nobody wants to deal with them, especially after we've labored so hard to close down a case in chief. But they're important, and they're oftentimes the last impediment to a full file closure, which is the ultimate goal. So let's jump in with the basics. First of all, what is a lien? So under Labor Code 4903, the appeals board can determine and allow as liens against any sum to be paid as compensation. So it's any reasonable attorney's fees. Some of you attorneys, of course, have seen applicants, attorneys who get out of the case early and they file a lien. Living expenses, burial expenses in death cases. We talk about those real fast. Make sure you get a receipt for the death cases. They're not, burial expenses are not due up to $10,000 until you get a lien. That's my first digression. I'll have many. Unemployment compensation, disability benefits, or any reasonable expense. So who's a lien claimant? Those are the good folks that we see at the board all the time, and I'll harken back to a time in the early 2000s when lien claimants would show up in jeans and a t-shirt, and then thankfully board rules were created which give them a dress code. So I think lien claimants are the only people that we deal with who actually have a dress code. So good on them. They've improved their appearance over the course of these last years. So I'm grateful for that. I didn't like dealing with them when they were wearing a Megadeth shirt and trying to collect a medical lien. Anyways, so the official medical fee schedule, obviously that is something that we throw around quite a bit, and it's what we rely upon in order to determine what a fee should be or what a lien should be paid at. There's dates for fee schedule provisions for medical reporting, of course, and medical treatment, and as well as copy service and pharmaceuticals. They all matter because that basically sets the bottom standard for what should be reasonable as an expense that's being put up against the defense. You can go to the web address down there. I got quite a few of these in the presentation for more information on the official medical fee schedule. I'm guessing if you've had any experience at the board on lien conferences, you're pretty familiar with this and pretty familiar that you're telling the lien claimant, hey, it's got to be official medical fee schedule. You can't bill 15 times over that, which they routinely do. So why do you care about the official medical fee schedule? Because it's important. Again, it sets the baseline for what is reasonable with regard to any type of litigation expense. Once you receive the lien notice, of course, you want to do a couple things. Checks for dates of service. For example, for copy service liens, there's a cutoff date. If anything before, I believe it's 2013, then the fee schedule was not yet applicable. So make sure you check, and a copy service lien claimant will tell you that immediately if you have an old lien. So make sure you check for dates of service and have the bill review, double check the explanations of review. For the claims adjusters out there, this is critical that we get a good explanation of review as attorneys. I'll lecture you on that a little bit more later on. But we want to make sure that at least that good faith actions have been taken to pay liens, because under 4603.2, there is penalty plus interest if properly documented bills are not paid within 45 days of receipt. And also there's potential attorney's fees. I have a good friend out there in the workers' compensation field named Bill Tappan, who makes quite a living doing this, and he's very adept at asserting penalties and interest where appropriate. So pay attention to these things. John's going to take the next couple. Go for it, John.
And Bill, we did have a question from Rachel about what is the date for that 45-day period of copy services? And I think it's, is it July 16th, 2022? Is that the effective date?
Yeah, we're going to talk about that later. It's actually, I think it's the 15th. You're off by one. Nice try, although I may be off by one. We'll see later, but it's definitely more clearly stated later on, Rachel. So we'll get to you. We're getting there.
And yeah, I did check the presentation. You're right. It does say July 15th. I think that was my flub, thinking that that was the end date of a prior period. So Rachel, I think it is July 15th. But moving on to Labor Code 4603.3 on our next slide, that actually talks about how there shall be an EOB. And let's see, I apologize. I think I have my slides mixed up here. Okay, so 4603.2 says that an employer may defer objecting to or paying any bill submitted by or on behalf of a provider. Basically, you don't have to take any action until the stay is lifted pursuant to Labor Code 4615. So 4615 is that stay statute, and typically the DWC has been staying liens who are related to criminal indictments and criminal issues. And so basically, if someone has been indicted, you'll often see on the EAMS public search tool that there has been that someone has been stayed. Also, certain providers are suspended for bad behavior. That's found in Labor Code 139.21. And often on the EAMS public search page, you'll see 139 or LC 139 on the right-hand side. That's someone who's been suspended. And an example of someone who's been suspended, had a doctor a few years ago on one of my cases who pled out on a criminal plea deal. As part of his agreement with the LA County District Attorney, he agreed to never practice work comp benefits again or work comp medicine again. So if you were to look up that provider's name, you'd see good old Labor Code 139 next to his lanes. Next slide, please.
Yeah, and I'll jump in real fast too. I know that, John, I've noticed lately a lot of or not a lot, but quite a few of the liens, the stays are being lifted because there was a whole bunch of indictments about 6-7 years ago, Dr. Rudolph and some other guys. And I know that those have since been lifted. So you may have a stayed lien, which is suddenly lifted, which you may have to deal with pretty soon. So double check and make sure that on the EAMS participant list to make sure the status.
Good idea, Bill. And moving on to Labor Code 4603.3, this is the statute that says that you shall prepare an EOB. And so what that means is you want to send that invoice or itemized bill to bill review. Your bill reviewer is going to say, what fee schedule is, any line item objections such as cascade or you didn't comply with this reg or that reg. They also list amount paid, amount billed, basis for adjustment, changes or denial, reason for denial if it's not a fee schedule dispute, so denied claim, for example, and contact information for dispute resolution. And there is more after that, second review, and this has come up quite a few times at our lien trials. So basically, if the provider disputes the amount on that EOR, they may request a second review within 90 days of service of that EOR. So the request for a second review has to be submitted to you, the defense, on a form, basically on the state form, indicating date of EOR, item and amount in dispute, additional amount requested, additional info requested. And next slide, please. And so that particular rule applies to all dates of service on and after January 1st, 2013. So now about 10 years ago. And keep in mind that's date of service, not date of injury. So in other words, that bill review rule only applies to, or does apply to dates of service after 1/1/13. And that second request form is available right there. So that's the form that they're going to have to use. Next slide, please.
Sure.
And sorry, Bill, I was off a little bit on the slide numbers. So I figured that this would be my last of the first batch. But basically, if the lien claimant does not request a second bill review within 90 days, the bill is deemed satisfied and neither the employer nor the employee shall be liable for any payment. And so one important thing about that last slide is that we've had that come up at lien trials before. And at a lien conference, for example, in 2019 or 2018, a client, even though I'd asked multiple times, they didn't send me the EORs or EOBs until about 11:50 in the morning at the end of my lien conference. Well, I got it continued to the afternoon. During my lunch break, I went and figured out the 300 dates for all those EORs and EOBs, scribbled them down, went back at 1:30. We got that lien case set for trial. And sure enough, there was 2 lien claimants who wound up giving up on about $10,000 to $15,000 worth of charges because they did not request that second bill review within 90 days. And those were better than average lien reps too. So yeah, if you are headed to a lien conference, you definitely want your defense attorney to have all those EOBs, EORs, because even though all the other facts in the case may be against you, if they did not comply with this one rule, that alone can save you tens of thousands of dollars.
Yeah, and we'll talk about complying with those deadlines again as it relates to independent bill review. But again, here's another digression. That's what I do. But I wanted to, I'm sure that many of you guys noticed that there's a 90-day response opportunity after a second review, and that mirrors what we have for medical legal reviews. So don't get them conflated. They're a little bit different. The timeframes are close. But I think the review under 4622 for med legal documentation is slightly different and certainly more punitive. But they are very similar, especially because there's 90 days for a second review. And as John said, it's really critical to construct a timeline after these things, because you may have no merit to your argument. That won't stop us, will it? No, because we can go in there with a statutory timeline argument, which should work. It is, again, these provisions are shall be completed, not you can do it if you want to. Okay, so what happens after this? So you go through that whole process of first review, your bill stinks, we're only paying this. Second review, we think that you didn't pay enough. Now what happens? So now, as John mentioned, since 2013, we have independent bill review. And so this is something that hopefully we don't have to get to. Hopefully we can resolve the liens by this, because independent bill reviews, you never know what you're going to get. I've had some pretty good results from it, and I've also had some disastrous results from it. So I think if you can avoid it, it's good. Sometimes, with the way the parties are going, maybe you just can't agree on anything. It's like a train, going downhill without brakes. It's going to hit it. So a couple things to remember with independent bill review. So it only applies to fee schedule disputes. So again, if there's something about a denial of the case or causation, that does not apply to independent bill review. They don't care about that. They'll send that back to you. It's only as to the amount paid and whether it was appropriately paid pursuant to fee schedule. Okay, so the process is under 4603.6, and again, it's only initiated after the second review has taken place and did not resolve the dispute. So the provider, the doctor, or the copy service provider, or whomever, the provider can request an independent bill review within 30 calendar days of service of the second review. This is another time when you want to do that little check on your calendar, because if they don't request it within 30 days, +5, the good old mailbox rule, remember that from law school. If they don't respond or request independent bill review within 30 days, then the bill shall be deemed satisfied. Again, I don't think this is something many folks know, and it's as John mentioned earlier, it's a good way to get out from under a hefty bill if you can. So here's the entire procedure from the start. We're going to go over a little bit of what we just did, but from the start, here's a pretty good little timeline for you. So the provider will say Dr. Black. He submits the request for payment, and our great claims adjuster issues payment, but only for a part of the bill, because as we know, and as this presentation is entitled, you can't spell liens with a lie, and most lien claimants tend to exaggerate substantially the actual amounts they're owed, hoping that a claims adjuster goes, okay, here's a check, boom. Please don't do that. Issue appropriate payment along with an explanation of review, which very clearly states the basis for why the additional payments were not paid. Should be because the payments and the billing did not adhere to the fee schedule. So the payment along with the EOR goes out to the provider. if the provider disputes that amount and requests a second review within 90 days of service of the first review, it has to be 90 days within the service of the EOR or the WCAB order that resolves a threshold issue, like AOE-COE. So, for example, if there is an AOE-COE trial and an issue, or I'm sorry, the issue is decided in favor of causation by the judge, if the other parts of the procedure have already taken place, meaning submitted the request for payment and the payment along with the EOR, then at that point, within 90 days after the order for causation issues from the judge, then the provider has to has to request bill review. I'm sorry, has to request a second review. If the second review is not requested within 90 days, again, the bill is deemed satisfied. We already said this. And if the second review is requested, a written determination is due within 14 days of the review of the request, and the undisputed amount is due within 21 days of the request. So if the provider disputes the amount after the second review, the independent bill review must be requested within 30 calendar days of service. Again, if not, the bill must be deemed satisfied. So again, on your calendars, when adjusters, when you send out your EORs after the second request, start counting 30 days, probably 30 plus 5 days, so 35 days total. And then maybe you can get out from under it if your claimant does not request bill review.
Bill?
Go.
Sorry, we do have one question that's popped up multiple times.
Okay.
So I figured I'd bring that to the table. Basically, people want to know how the second bill review request, whether it's IBR or the first one we were talking about under 4603.2, how does that apply in denied claims?
Well, there has to be a determination of causation first, and that's what I was just talking about here. So in a denied claim, I think the procedure is stayed until there's a decision or determination regarding acceptance or an order for acceptance of the case. So under a denied case, you don't have to pay anything, obviously, because as long as your denial is made in good faith, you can stand by it. However, if for some reason, say there's an AOE-COE determination, that is when the clock again starts ticking for the decision to go out. So that doesn't make sense. That's when once you get the order from the judge finding causation, at that point the clock starts ticking for the procedures again. So if you do if a provider submits a request for payment and the response is case denied, shut up until we have a causation determination. So once the causation determination is made, whether it's voluntarily by way of accepted case or involuntarily by way of order, findings and award, that starts the clock right there. So once that determination is issued, again, whether acceptance letter or F&A, then that's when the clock starts again. Does that answer it?
Yeah, and we did have a follow-up question from managing attorney and partner Patricia Carlos. Is there an obligation to inform lien claimants who are or aren't a record of that F&A? And I think my interpretation of that is the F&A goes to the parties who are of record, and then you have your certain providers who may not be entitled to medical information. So those providers would have to petition for F&A, for example, that does have medical information in there. But then again, if they are of record and they are on EAMS, then they can get it themselves. So I think most of them are going to figure that out in their petition. But I don't think there's a obligation to inform any potential and all lien claimants who may or may not be of record of a causation determination. Would you agree with that, Bill?
I would agree with that. I think, as you mentioned, John, I think the obligation starts and stops at serving the parties on the EAMS participant list, the official parties to the action. If there's no lien filed, then nobody's a party. I definitely think there's no obligation, even if you're aware that Supreme Copy or some other one of those other copy services is providing services. I don't believe there's an obligation to do that. I think the obligation starts and stops with the service obligations pursuant to the participants of the WCAB. Do we handle that, John, you think?
Yeah, I think we did. And we do have a ton more questions. So what we'll do is we'll try and answer a few more through the presentation, but we will also be emailing back answers after the presentation as well.
Yeah, we got stuff to get through, people. We got to work here. So no, but we'll definitely. I saved back an hour after this presentation, so I'll happily answer some questions or take phone calls. If you guys know me, it's always nice to catch up. We'll even talk some LA Kings hockey. Okay, back to the procedures here. Okay, so I think I left off at the independent bill reviewer assignment. So if the provider requests assignment of independent bill review, then it has to be assigned within 30 days of the request to the independent bill reviewer. The independent bill reviewer, this is the part I like actually. The independent bill reviewer can request documents of the employer or the provider, but the employer initially has no obligation to provide the independent bill reviewer with documentation. All of that falls on to the provider. So I had this one really bad case. I won't mention the lien claimant in case she's watching, but you know who you are, where she was telling me that I was obligated to provide independent bill review with the documentation. And I just refused to do so. And eventually the judge sided with me and says, you know, under the code, there's no obligation for the defendant unless the independent bill reviewer specifically requests documentation. So let the provider do it. They also have to pay the fee, which is $250, and you may have to reimburse the fee if it's found that additional money is owed, but they absolutely have to front the fee and initiate the process. Okay, so within 60 days of the receipt of assignment, the independent bill reviewer shall make any written determination of amounts paid. So you get an order which is essentially enforceable by the court. So here's one other thing that's critical to take into consideration, because one thing that I've noticed that lien claimants do, not to say everyone, but many of them, a little shady, they'll just keep sending you bills over and over and over. And so as a claims adjuster, you're inundated already. You're already getting all kinds of mail every single day that you don't know what to do with. If you're getting repeat requests for repeat submissions, excuse me, then no further or additional notification or objection is made as long as you made the initial objection. So again, this is where you document your file and you make sure, hey, I responded to you and I said your bill stinks and I'm not paying it. As long as you do that once, if they send you the bill again, that doesn't give you another obligation to respond to them. You can say, hey, talk to the hand. I already responded to this. Okay, so remember that. Is this where you take off, John? Is this where you go?
You know what? I figured I'd just stick by the original slide numbers and keep things a little simpler.
And you've been known to wear wigs like that, so it kind of fits in. Go ahead.
Yeah. So talking about IBR procedure, these are orders from the AD. So these are final and binding because the administrative director is as close to we get to royalty and work comp, right? So that's final and binding until an appeal is filed with the WCAB, and that determination is presumed correct. And if someone does appeal, it's one of those situations where the AD is going to get some deference. It better be a really good appeal if they're going to overturn that. Next slide, please. And so in order to set aside the AD's order, they have to show that the administrative director acted without or in excess of her powers, fraud, there's a material conflict of interest, there's some kind of unlawful bias, race, national origin, sex, sexual orientation, that kind of thing, or there's a flat out mistake, a really gross mistake or something that's just plainly wrong. For example, the person who made the determination didn't know about this really important medical report, which said something contradictory. So those are the kind of things that are going to be necessary for an appeal. Next slide.
Yeah, and remember, attorney friends, it's by clear and convincing evidence, which I'm sure you'll remember from your early procedure classes, is one of the highest standards that we can get to. So, yeah, you have to have your ducks in a row before you're going to be able to overturn one.
Now, moving on to med legal billing, this is something we've seen come up, especially the last like 5-6 years at lien conferences, where you have a lien claimant who's billing all 36 dates of service as med legal. And does this happen all the time? Of course. And so why? People are trying to pull end runs around UR or IMR, and it's also a great way to try and bill under the med legal fee schedule. Unfortunately, most of these types of services, if they're from treaters and not QMEs or AMEs, they don't get to bill under med legal. So here's the applicable reg you want to know, CCR 9793 subsection H, which defines med legal expense. And it's cost or expenses incurred for diagnostic tests, medical records, medical testimony, basically stuff for proving or disproving facts or issues in a contested claim. So what is a contested claim? As most of you can imagine, that is a denied claim. So in other words, number one here, where an administrator has rejected liability for a claim benefit. Number two, where a TPA has failed to accept liability for a claim and the claim is presumed compensable under 5402. Number three, where the TPA has failed to respond to a demand for payment. And number four, where it's an accepted claim, but there's a disputed medical fact, such as TD, PD, could be medical treatment. All those can be disputed medical facts. A body part is another disputed medical fact. And so this reg defines that in greater clarity. So medical condition, which can mean body parts, cause of medical condition, again, going to body parts. And both of those can also go to future medical treatment. The existence, nature, duration, or extent of temporary or permanent disability, so TD or PD, and eligibility for rehab services. And that also kind of touches on work restrictions as well. And next slide, please. So how do you resolve contested claims? So 4060 refers to disputed claims, as in we have a straight up AOE COE dispute where we aren't liable at all. Disputed facts, 4061, 4062, those are PD and TD, objection to medical determinations. And then also these sections have in common, well, they all fall under Labor Code 4061 and 4062.2. And so that refers to the med legal process involving QMEs. So most med legal billing is going to fall under QMEs or AMEs because 4062.1 and 4062.2, which encompass that batch of statutes that we just looked at, those all deal with QMEs or AMEs. Next slide. And so this leads us to the next question. Is all diagnostic testing then med legal? They are rarely med legal. It's your lien claimant who's just trying to catch you asleep at the wheel. And part of the reason why is that even though, so for example, if you look lower on the slide here, we're noting, is the person who requested those studies a QME? Well, if the answer is no, let's walk through that. If it's a PTP, were those slides necessary to prove or disprove a contested fact? And so not all diagnostic studies are necessary for that. And so and often you'll see PTPs requesting a ton of diagnostic studies on accepted cases, and often it's just not necessary. Next slide, please. So if it's a PTP requesting that, I would contend that it's usually not med legal. Moving on to DME. Now, Your Honor, lien claimant love for TENS units to cost $25,000. In fact, all those batteries cost about $1,000 a piece. The electrodes, oh my, I mean, those got to be at least $600 a piece. And there's tape. Tape has got to be really expensive. And then mysterious supplies. And I've seen under supplies, the box that they shipped it in, billed at $150 for the cardboard box. So often on this particular example, one thing that you can do, or anyone can do to help fight a DME claim, especially on a TENS unit, is just use Google. Google the code that they're billing it under, or Google TENS unit, and Google IBR or IMR with it. And the reason why is if you Google it with that information with IMR, what's going to come up is a bunch of IMR decisions saying why that TENS unit was not reasonable and necessary. And often those are on accepted cases. So even if you have a case where all the facts are against you, if your IMR decision has a checklist of 5 or 6 different things that needed to happen before that TENS unit becomes reasonable and necessary, apply that to your case. Did they check all 5 or 6 factors? No. That's led us to wins at lien trials. You Google IBR decisions on TENS units, and even though you may not be a bill reviewer yourself, you can find an IBR decision that says that the TENS unit that you're looking at actually only cost about $350, and those electrodes were $13.50 a piece. So that's useful information. Google is your friend, and you can definitely use it to fight liens. Next slide, please. Some practice pointers for DME. You want to demand those prescriptions from the treating physician. And often those look sketchy. I often wonder where those come from, if they did actually come from the PTP. They will often be able to produce it, but you want to take a close look at that and make sure that that wasn't fabricated at someplace it shouldn't have been. Demand verification that the applicant actually got the equipment and was given an explanation how to use it. They can't always produce documentation of that. Often they will be able to comply with our third point, which is, did the referring doctor say why the DME was prescribed? Often they'll have a paragraph copy pasted into their report. Number 4, they often will not comment on whether it helped. It's funny, despite all this equipment, it really just doesn't help. It's a big surprise. At the end of all this treatment, their PD actually went higher. Can you believe it? And of course, I'm being sarcastic there, but demand invoices as well. And again, circling back, is the applicant actually using the DME? And that's often a question we'll ask at the depots. Did anyone give you any medical devices to use? Do you use them? Do they help? And that's also something to pay attention to in the QME narratives when they go to the QME, because the QME will often ask them, hey, what treatment have you been doing? And so pay attention to that QME report, see if in their narrative, if they say whether they're using DME. And Bill, I'll kick it back to you for TAPIA.
Well, thank you, John. Back to me. Okay, so if you're litigating on DME, you're going to be, of course, as John indicated, fighting against an unreasonably crazy high bill. I've seen, John, I'm sure you have, I'm sure we all have battery packs that are like $80, which I simply don't get. They're AAAs, for crying out loud. In any event, there's some other things that we can do to defend against these unreasonable charges. And one thing that some lien claimants will do is they'll try and use justification for market value to prove that their charges are reasonable. So remember that market value is, it's just one tiny little thread in a big sweater of defenses. So they may say, yeah, market value in Beverly Hills is for a $2,000 DME. Well, that's great, but that's not applicable, obviously, intuitively to other parts of our state. So I always tend to say the market rate arguments are kind of lame, and I think most judges agree. By the time you get to a trial, many judges have tried DMEs, and in general, I think the judges dislike the unreasonable billing. In fact, I had a trial the other day in Marina Del Rey with a good judge there, and when the lien claimant was trying to justify the DME and MRIs, the judge was like, oh, it sounds like this is puffy billing. And so I think the judges know it, and they'll kind of call them out on it more and more these days. But nevertheless, you still want to be prepared and have an answer, at least, if they say, well, hey, I get paid $5,000 for DME equipment when I bring these cases in Long Beach. don't get me started on Long Beach. But again, that's just one small bit. That's not conclusive. They can argue that. I think you argue against that by saying, Judge, okay, that's great for Long Beach. We're not in Long Beach. We're somewhere else. We're in San Diego. That isn't applicable. The charges down here, Your Honor, you're more familiar with. Or by contrast, you can demonstrate amounts that have been paid. If you know that this argument is coming, you can demonstrate payments in the past on your DME stuff.
And actually, on Bill's point, just hopping over to copy services real quick, that this is unreasonable argument. A great argument with copy services is try and figure out the value per page that they're billing. So if their bill is for $10,000, but they only copied 100 pages, point out that what they're saying per page is reasonable. And often, if you can make the argument that, Judge, this copy service is arguing that their services are entitled to be reimbursed at $10 a page, most judges are going to say $10 a page. Yeah, right. And so often you can boil that down, boil it down further. But yeah, many judges are going to laugh at $5 to $10 a page. And many lien claimants are trying to bill at that rate for the copy services. Sorry, Bill, go back to you.
No, all good. I'm happy you jumped in. Just a little bit more on the DME stuff. Remember that anybody that dispenses the DME equipment has to have a license. There's internet page you can go to right there if you need to click onto it or save it later just to look and see and make sure that the person who distributed the items is allowed to distribute those items. Before we get into pharmaceuticals, and I know we got about 15 minutes left, I do want to go back real fast to one thing about what John was talking about with med legal expenses. And sorry I told you I was going to digress. This is a little more of a regress, but I had a case with Med Legal LLC, may they rest in peace, and where they were alleging that the documents they got were med legal, and I said they weren't, and I said it's their burden to demonstrate that they were. And so it's the claimant's burden to demonstrate why anything is med legal. And when I did that one, the med legal rep went humana, and had no really good response. And when I got the decision, it was favorable. They kicked out the rest of their liens. So just remember that too, is that the burden is on the claimants for many of these things. Okay, now let's switch to my favorite part of this whole presentation, the pharmaceuticals, brother. This is where it gets fun. Okay, so pharmaceuticals obviously are problematic. I think we've backed off a little bit from the compound medications, which were in vogue about 5-6 years ago, when every single bill was, $1,800 for 2 ounces of medication. Thankfully, I think that's been cracked down on. Thank you for the indictments, Mr. District Attorney. I think that helped. But here, you still have some pharmaceutical issues and some issues to contend with anytime that you have a pharmaceutical lien. So make sure to identify the prescribing doctor, because the request for medication must come from the primary treating physician. This is per 9785. Remember, the treating physician is supposed to be the person in charge of the applicant's treatment and is the doctor tasked with medications. Compare medical reports and make sure that the medication is necessary and reasonably required to treat injury. On that trial I had on Monday, there was a claim for internal injuries that was found to be non-industrial by an AME. And the pharmacy had bills, had distributed medications both for the orthopedic portion, which was accepted and compensable, and the internal portion, which was not compensable. So I had to go line item by line item and make sure that the medications that were dispensed for the internal injury were stricken because they were not industrially related. Confirm receipt of the medication. I think John alluded to this earlier about using a QME. Make sure that go look at the QME reports and see if the applicant's informing the QME that he or she is actually using these medications, or ask them in deposition for the attorneys. Say, hey, you taking these medications that we're seeing, bills for? Is the medication helping? Are you just letting it sit on your dresser? Or are you giving it to your friends? So make sure that they're actually receiving and taking the medications. because otherwise it's not compensable. Repackaged pharmaceuticals are when the treating physician may, out of his or her office, give away some medications to the patients. Thankfully, as a patient, I get some of these freebies sometimes from my doctor, but under the insurance code, they are not compensable. So if a doctor is given free samples and said, hey, give these to your patients, and that person, the doctor, gives that medication to an injured worker, that doctor is not entitled to payment for that. So it's free. It's not a dispensed item that the doctor incurred an expense for, and it's not something that's reimbursable. And I'm sorry, I'm trying to move along a little bit more because I know we're getting up against time here. So here, back to compound medications. Again, I think this is, we're not seeing this as much as we were 5-6 years ago. Thank God. It was always a pain in the butt for these things. But remember, so the billing is at the ingredient level with the National Drug Code indicated. Ingredients without the National Drug Code are not reimbursable. So make sure you're looking up the National Drug Code to make sure that it's something that's appropriate. They're reimbursed 100% of Medi-Cal plus a dispensing fee. And if it's dispensed by a doctor, reimbursement shall not exceed 300% of the documented paid cost or no more than $20 above documented pay costs. So, and remember also that not only are doctors required to prescribe generic medications before they switch to compound, they're also obligated to justify the compound medications. No longer can they just say, hey, here's, you know, $8,000 in compound medications. You have to say why the other medications did not work, and compound medications were the only thing that were going to work. In deposition for a long time, I was asking, hey, do you take these compound medications I'm seeing? 9 times out of 10, these medications don't work. They're topical creams. I think their efficacy level is pretty low overall. So the creams in particular, I think, are just absurd. So demand the quantity of the compounds. What is the recipe? And then once you have the recipe, you can go to this URL right here, and you can get a better understanding to make sure they are compliant with the NDC and there's something that are actually reimbursable. Okay, so secondary physicians. Oh man, we deal with a lot of these guys and gals, and you know, sometimes they're good to us, sometimes they're bad to us, but they always seem to show up for lien conferences. Of course, a PTP can refer the injured worker out for a secondary physician's review. This happens a lot with chiropractors. This is why you don't want your PTP to be a chiropractor, because they're going to refer them out to the orthopedist, who should probably be the PTP, but that's another presentation altogether. So they are allowed to do so, but the secondary physician shall report to the PTP, and the PTP is responsible to take those reports and basically boil them down and make the findings and issue the request for authorization. That's on the PTP. If you're getting that from secondary physicians, you can deny them because they're not from the PTP. So this is something that is routinely not complied with. We get RFAs, I know, from secondary physicians all the time. And sometimes just for expediency's sake, I understand why maybe they're submitted to UR, but they don't have to be. It has to come from the primary treating physician, who is the doctor in charge of the applicant's overall care. We touched on this a little bit earlier, both John and I, with regard to utilizing the AME and QME to help undermine some lien claims. Ask about the medications, ask about the types of treatment, the durable medical equipment. Are these things, Mr. QME, that are being utilized? Now, I understand that as attorneys in particular, our efforts at writing pretty good advocacy letters have been hampered by the Maxim case. If you don't know that, that's another whole presentation about what information can and can't be provided to a doctor. And it limits basically what you can do. So, but you can always try to ask these detailed questions And, you know, in many cases, the applicant's attorney wants these questions answered too. So if the applicant's attorney doesn't object, submit your advocacy letter and we're all good. If the attorney does object, well, then you can't submit it. That's what the code says. You're simply out of luck. But I still don't see a problem with trying. And I'm not saying be underhanded. I'm not saying do something that's you know, not ethical. I'm just saying if you're asking reasonable questions and reporting to an AME or a QME, it's okay to give them some facts that aren't disputed. It may get disputed, or your letter may be disputed, but I think if you're acting in good faith, it's not a bad idea to do. And so, Bill, because again, these, oh, go ahead, John.
And actually, to Bill's point, one thing that is, well, one thing that's really worth noting is that I'd say about 10%, maybe 20% of the QMEs out there really dislike chiropractors and really dislike non-MDs. And so sometimes you don't even have to, and while it is good to ask, you know, what do you think about the PTP? Sometimes if the applicant's attorney is objecting, if you just point out that, hey, this person's been treating with a chiro for a knee injury for a year and a half, your better ortho QMEs are going to say, what? You know, knee injuries shouldn't be treated by chiros. I don't know why the applicant's attorney would do that. That is totally not necessary. And they just throw the PTP under the bus. And I'd say about 2 or 3 times a year, I get a QME report like that. Just because the MD simply doesn't like chiros or the treatment was not appropriate. So keep an eye out for that in your letters. And as far as underhanded, Bill, I don't know what you're talking about. I would never put 1,000 words of boring stuff and then 2 killer questions right at the end.
It's a good strategy. Yeah, those MDs that have to do residency and have, you know, hundreds of thousands in student loan, for some reason they don't like the guys that go to the chiropractic college. I don't know why. All right, moving on. Let's get to it. We got just a few minutes here, John. We got 7 minutes and a whole crap ton of slides. So we'll cut through this stuff pretty fast. Sorry, we're verbose. We get paid by the word. Interpreters. Okay, qualified interpreters. Of course, an applicant is entitled to one. I see these guys all the time, especially as it pertains to depositions and 5811 charges for courts. Remember that an interpreter has to be certified. Generally, the interpreters know this. If you have a deposition nowadays, they'll give you their certification number. They don't have to be certified if the parties agree, but for the most part, I think it's not that hard to become a qualified interpreter. I mean, I guess that's easy for me to say. I'm not one, but I think for the most part, the interpreters these days are certified. I very rarely see that objection. Remember, the interpreter has the burden of proving that the charges were reasonably required, the services rather were reasonably required. So if you got, you know, John Smith who's asking for a Spanish language interpreter, maybe look into that a little bit. And that the services were actually provided. I've had depots where the applicant just started speaking English, and so the interpreter that we have sitting there was no longer appropriate. All right, and remember now, interpreters are finding a way to get around the regular charges of liens, and they're coming back with the 5811 reimbursement for costs. Remember, these are specific events. They're listed down below. A qualified interpreter may render services during the following: deposition, appeals board hearing, a medical treatment appointment, or during those settings which the administrative director determines it's necessary to ascertain the applicant's proficiency in English. So yeah, that's starting to happen more and more. Pay your interpreters and get them out of the way, in my opinion. The filing fee, I mean, this is from 2013, so 10 years ago. Wow, remember when this was a big deal? That was 10 years ago now. So the filing fee is now required. There must be proof that it must be paid. And of course, when filing a lien, a DOR, a lien claimant has to verify under penalty of perjury that it wasn't subject to IMBR or IBR. If they don't do this, remember it's under penalty of perjury. Judges don't like it when that is skipped, so pay attention to that one. All right, John, I think you're on.
Okay, and so yeah, it does actually pay to be nice even to lien claimants, and a good example of that is I was at a lien conference in February 2020. I mentioned to a lien claimant I know, we were talking about stocks, and I mentioned, hey, you might want to buy some of that Moderna stock. And so about a year later, when we had another lien conference, he was so grateful for that tip that he said, oh yeah, we can settle this lien for 10% or 5%.
It's a good thing you didn't say crypto.
Yeah. So anyway, it's kind of funny how stuff like that works. But going back to the DOR slide, if you have a lien claimant who is filing a DOR and they lie about, this lien claim is actually subject to IMR or IBR, and they kind of ignore that, that gives rise to costs and sanctions. And that leads to another issue. If your lien claimant has no basis to actually, so if they have a totally insufficient case, they don't have the exhibits, they can't get there, that leads to Tito Torres, and that's that M-Bank decision from years ago where the board found that the defendant was entitled to cost and sanctions because the lien claimant just brought a completely inadequate case. And so where a strategy point is, if you do have a lien conference with a bunch of lien claimants and some of them are not above board, you may just want to write those two magic words on the issues page there, Tito Torres, just in case. And the reason why is that if you do wind up at trial and someone has one exhibit and they really needed 10, then you can use that to leverage them to exit the case right away and nominal settlement. Next slide, please.
It's that one.
And yeah, so checking out the statutes of limitation, we worried about this a lot more about 5 or 6 years ago. But yeah, your data service after 7/1/13 is going to be 18-month statute of limitation. Data service for your older liens, or zombie liens as they used to be called, for dates of service before July 1st, 2013, that's going to be 3 years from that last data service. And so last data service is your keyword there if you are looking at zombie liens or older liens. Now, don't jump the gun. You want lien claimants to file. There's no filing or serving until 60 days after the claim has been accepted or denied, and 60 days after the 90-day investigation period, whichever is earlier. And also 4903.6 subsections A2, no filing or serving until 45 days to pay for treatment have elapsed, or no filing and serving until 60 days to pay for med legal have elapsed. So in other words, those lien claimants, they have to abide by those rules when to file their liens. Another thing you want to take a look at, and I know we're right up against it, 2 minutes to go. Another key issue to list on your issues page is unlawful assignment. And the reason why, SIGA pushed for this great anti-assignment legislation years ago, because you had providers selling their paper to just random finance companies who are willing to buy, $2 million worth of liens, hoping to settle for 10 cents on the dollar or 20 cents on the dollar. So unlawful assignment is always a defense worth listing or mentioning out there, especially if you have those older lien claimants who you think, gee, didn't they go under a few years ago? Well, then this may just apply to them. And if it was someone who did change hands over the years, you get to insist on proof that there is no unlawful assignment. And often evidence of assignment is available online as well. So again, Google is your friend. And you're also free to ask us if there's evidence that a particular lien claimant who you think was doing unlawful assignments did actually do that.
John, I'm going to skip ahead a little bit here because I did want to get to the copy service fees, especially I don't want to let Rachel down. She asked that question earlier and I wanted to make sure we got to this. So sorry, I'm just trying to expedite this so we can get in with our timeline and get everybody back to their lives. So real quickly, we talked about this earlier. The copy service fee schedule went into effect July 1st, 2015 and was modified in 2022. It includes a flat rate system. As of July 15th, 2022, the flat rate has gone up as we'll see right here. These are for dates of service prior to 7/15/22. It's a $180 flat fee, and it includes all those items, which is basically everything. So if they're serving copying documents or providing subpoenas, this is the flat rate right there, and it seems to be a pretty inclusive paragraph for all the things that they're doing. Again, here's 7/15, it's gone up. So the charge for cancellation now, $75 for cancellation after subpoena request for records has been issued. $20 for records obtained from EDD, $30 for records from the WCAB. And I'm sorry, that was from before 7/15. Now they've gone up after 7/18 to the $230 flat rate for the initial set of records as set forth in that previous long paragraph. $75 is still the cancellation fee. And and so the fees have gone up only slightly, but I know the copy services are going to constantly refer to the official medical fee schedule, which is a good thing for us because copy services were pretty out of control too. So, John, you want to bring us home with these last few?
So yeah, you do want to be wary of the new penalty subsection. Basically, if bills are not paid or contested, EOB, within 30 days, the billed sum will be increased by 25%. And Bill, actually, can you wrap it up? I'm sorry, having a little cough.
Oh, sure, no problem. So yeah, per evidence code for non-approved vendors, I know that a lot of times for claims adjusters, certainly we have our approved vendors that we like to use on the defense. However, eventually we can't issue an appropriate and plausible objection for non-approved vendors. So ultimately, you have to pay for the Joyce Altmans of the world, even though I don't think they're approved by any defense side. So with that, there's a little bit here about quashing a subpoena. I apologize, but I think we're running into the end of it. I know we're not supposed to go over. The State Bar is going to get mad at us. So if you please review these last few pages if you'd like, feel free to send John or me any questions. We're happy that we get this opportunity to talk to everybody, many people that we know out there, hello, and the people that we don't, give us a call or an email and we'll be happy to answer any questions that we didn't hit.
Thank you both. Thank you both so very much. I think that next slide also has your contact information on it. There you go. So if you guys do need to contact them, there's their contact information. Thank you again for presenting today, and thank you all so much for attending. A couple of very quick reminders. Certificates for CE and MCLE will be emailed within 24 hours. Several of you asked about the PowerPoint. You can find it on our external website under training and today's event. There's a link there, and we do that for every single webinar. There's a PowerPoint attached to each event, and we always get it on, or we usually do, before the event starts. Our next webinar is on Valentine's Day, February 14th at noon, on bad faith claims, again with Bill and John. We get them for 2 months in a row. Very exciting. Thank you again for joining us, everybody. Have a wonderful afternoon. Take care.
Thank you, everybody. Have a great day.